I will now call the case 125241, State of Kansas versus Francisco Alejandro Mendez. Counsel, please come forward.
Hey, please the court. Once again, I'm James Latta of the Appellate Defender's Office, and I'm representing Mr. Mendez. As this court knows, this is a case with many convictions. We have a murder conviction, multiple attempted murder convictions, and multiple aggravated robbery convictions. My plan today is to focus on the sufficiency issues, specifically the insufficiency of premeditation and insufficiency of some of the aggravated robbery convictions. If this court wishes to talk about any other issues, I please ask this court to direct me to do so because I want to talk about what your honors want to talk about. So beginning with premeditation, as this court, and I'm well aware this court does not like to find insufficiency of the evidence for premeditation. So in this case, my best argument, look, as a brief reminder, we're talking about incident, as I briefed it in my brief, incident number 3, where there was a Washburn party, and there was some football players from the Washburn University football team standing out in the front yard discussing what to do after the party. And according to the football players, a car drove up, asked them some questions, asked them if they had any marijuana. They said no. Another person in the vehicle asked them for their name. So one of the football players responded, "Don't worry about it." And according to the state's theory of the case, it was that answer, that disrespect, that then led to a shooting, as the prosecutor himself said in closing arguments a couple seconds later. So my best argument to distinguish this case from the many other cases where this court declined to find insufficient evidence for premeditation was the state's own theory of the case was that this was an impulsive killing. So there was no premeditation based on the impulsive killing. The state itself started closing argument by saying, do you guys have any weed? What's your name? Based on those two questions, the prosecutor said, and in the time it took me to ask those questions, and in the time it took this defendant to ask that question, do you have any weed? The decision to take a life was made. And then later on in that same closing argument, the prosecutor said that was a couple seconds. So our argument is that based on the state's theory of the case, they themselves conceded that there was insufficient evidence of premeditation, because the only way you can have a second-degree murder, as I've argued with this court before, is an impulsive killing. And in this case,
didn't the shooting last a number of minutes with as many as 3 different guns, and there were 18 shell casings found?
I don't believe it lasted a couple of minutes. I believe it all happened very quickly within seconds. But I will concede that the shooting lasted more than a couple seconds.
And there were people, at least one person who was shot in the back after starting to run away.
That is correct. So my best argument that I have to say that these facts, when we review the sufficiency of the evidence, as this court has said many times, we view the evidence in the light most favorable to the state. And I will point out, I looked at it yesterday, and I can't find one case that this court has said that in thousands of cases based on my research. This court has never said that we view the facts in the light most favorable to uphold a conviction, even though there's been numerous opportunities to do so. So my argument is that when we view the facts in the light most favorable to the state, we view the facts in the favor of the state's theory of the case. Because to do otherwise would be to not view the case in the light most favorable to the state.
Does that mean we have to ignore the actual evidence, the testimony that it was, what, 10 or 15 seconds between shots or when the shot occurred? My point being that we have evidence from a witness, right or wrong, but evidence that's there that says 10 or 15 seconds. And then you're saying the state comes in at closing and says a couple of seconds, that we have to ignore the evidence and hold the state to whatever a couple of seconds means? That doesn't make sense to me.
That is my best argument I have to get around the standard of review that's very unfavorable to me.
Jury certainly wouldn't have been instructed consistent with that theory, would they?
No, but the prosecutor in his closing arguments, in my opinion, lowered the burden for premeditation by noting that it could occur within 1 second in one place. And then even when he started his argument talking about in just that time it took to ask those questions, was a very, very small amount of time. And so if the state had alternative theories of the case, I think the facts could support him. But my argument is that when the state comes in, they say, this is our theory. I mean, to me, it doesn't make sense to say the jury convicted on a theory not put before them.
All I meant is that the jury wouldn't have been instructed to consider only evidence that supported the state's theory. They can consider evidence admitted and that they were the finder of fact.
I agree, Your Honor. My argument is this: the best argument I have is that when the state puts forth its theory of the case and they convict, I think it's reasonable to assume that they convicted under that theory. There's no questions on premeditation. I'll move along to the aggravated robbery convictions. And in this case specifically, I'm asking this court to overturn 4 of the aggravated robbery convictions. As this court remembers, there was 2 different incidents of alleged aggravated robbery. The first one occurred when the vehicle was stolen, and there were 2 alleged victims in the vehicle. And then a few nights later, there was another incident where there was a group of alleged victims in a vehicle, and supposedly Mr. Mendez came up and was part of a group that robbed them. And so my argument is that for the people that had nothing taken from them, there is no aggravated robbery. There is at most an attempted aggravated robbery. And specifically, I'll focus on the first incident, which is when the car was supposedly taken. The passenger in the car, his name was Will Clark. And the state's argument is that they had to get him out of the car to be able to steal the car. And I'll agree that that is true. But what makes this difference is this court's case law says that the gravamen of robbery is the taking of property. And Mr. Clark, he had no possession or control over the car. So even if the robbery hadn't occurred, he was not in a position to be able to control the car or say who could come in the car or had any possession over it. So in that case, there's no robbery because nothing was taken.
He was the first to leave the car, as I recall, correct? Did he leave the car before the driver relinquished the car?
I believe that is correct because I believe the driver stayed in the car refusing to get out for a little while.
Is there an ownership requirement or a property interest requirement in the aggravated robbery statute?
No, I don't believe so.
So why isn't the taking of the car from the presence of Clark sufficient?
Because this court has said that presence doesn't literally mean present while something is taken. This court has said that it means you have some possession or control. He was not in possession or control of the car. Just because you have to, someone is making it difficult for you to take something that isn't theirs or they have no possession of, that's not a robbery, because robbery we're focused on the taking of property. So if nothing's taken from his possession or control, there's no robbery. There might be some other crimes to remove him, but there's no robbery.
So your argument hinges on the lack of control of the car?
Yes.
But as I read our case law, it has to be a presence that's of the nature that it required force or threat of force to remove that individual from the property. But for, an armed robbery, this passenger would not have been depossessed of that vehicle. Or how would you respond to that argument?
I mean, I would say he was never in possession to begin with. So how can possession or control be taken from you when you don't have it to begin with? I mean, he wasn't driving the car. I mean, you can get possession and control lots of ways. If someone said, drive my car somewhere, then I'll concede that they're in possession and control of the car, even though it's not theirs. And if someone else was driving it, they wouldn't be. But that just isn't the case here. I mean, there's lots of other crimes for forcing him, battery, threat, but it's just not robbery. Think of the hypotheticals we could come up with.
Well, we have lots of, I think, Fourth Amendment cases in which courts have found that items inside of a car are in the control of passengers.
Sure. I would say that Fourth Amendment doesn't apply here.
Well, I know, but conceptually, the question of whether or not a passenger controls property of the car or the contents of the glove box or what have you has been litigated before. Courts have found that passengers do exercise some control over that property.
Sure, my response would be if that's the case, and that's certainly not what happens here. I mean, he doesn't have any, he can't direct where the car goes. He could ask the driver, but she has her own free will what to do. Without the robbery, my basic argument is if you're not in possession and control before a robbery begins, we can't say afterwards you were in possession and control. I mean, like I was getting ready to say, the hypotheticals we could come up with. I mean, if you rob one person in a football stadium, I mean, did you have 50,000 robberies?
And just to clarify, you're arguing against 4 of the ag robbery convictions.
Yes.
We've just talked about Clark.
Right.
And the other 3 are Cool, Hodge, and Farah Fontoff.
That is correct. And those were from the last incident. And in that case, there was nothing taken from them either in all those. And the state concedes Cool. That Cool was.
Thank you.
And so I guess since you brought that up, I think we know that when they say got their pockets run, kind of a slang phrase. I cited a case where they've talked about that just means they're looking to see what you have. And even if this court doesn't want to rely on other cases, the state never got any evidence of what that phrase really means. So either way, that has to go against the state that nothing was taken from those.
So the state conceded as to Cool.
That is correct.
Right. But as to the other 2 on that Central Park incident, there was testimony from Strika. I don't know if I'm pronouncing that correctly. And it was, that testimony was, but as far as I know, Hodge, he got his pockets ran, so did Farah. Cool's the only one they didn't get nothing out of. So those 2 sentences together, could a jury reasonably infer that running of the pockets combined with Cool being the only one that didn't get something taken from them support the convictions for those 2 victims?
I don't think so because, would you mind reading that again? I'm sorry, Your Honor, I don't usually do that.
Yeah. This is from Strika, but as far as I knew, Hodge, he got his pockets ran. So did Farah. Cool's the only one that they didn't get nothing out of.
Sure, and my argument would be reading that all together in context. We don't know for sure that they got any. I mean, even viewing in the light most favorable to the state, we don't know for sure they got anything taken from them. They said they got their pockets ran. I mean, my argument would be that that's not conclusive enough to find beyond a reasonable doubt that they had something. And I believe there was other testimony later that their pockets were looked into, but there was never any conclusive testimony that something was taken.
I guess it's, yeah, the pockets ran, but it's coupled with the testimony that this other third party, Cool, was the only one they didn't get anything out of.
My response would be reading it in context. It would still uncertain because they only said they got their pockets ran is my response. There's no other questions, Your Honors. I just ask that this court reverse and remand consistent with my brief, please.
Thank you, Mr. Ladd.
Thank you.
Thank you, Your Honor. Good morning. May it please the court. The state appears by Deputy District Attorney Jody Litfin. I'm going to stick with the sufficiency issues as well, unless this court has any questions. As far as the first issue, our position is that the state presented sufficient evidence here to convict the defendant of premeditated first-degree murder and the 4 counts of premeditated attempted murder. And again, we've talked about the standard, viewing the evidence in the light most favorable to the state, not the prosecutor's comments. So we have to stick to the evidence here. Even the gravest offenses can be based on circumstantial evidence. And there are 5 factors that this court has commonly used to go through finding inferences of premeditation. And the first being the nature of the weapon used. And here there were guns used. A gun is unquestionably a deadly weapon. The shooting involved 3 different guns, 18 shell casings, the revolver bullet that was eventually found in the victim's head. There was a large number of shots here, so that infers premeditation. There's case law saying this. And the witnesses described the shooting as being slow at first and then more rapid. And then everyone ran. And then, as Your Honor was saying about the other victim who got shot in the backside, indicating that he was running away and they were still shooting. The bullet that came from Simmons came from a revolver. I'm sorry, the bullet that killed Simmons came from a revolver. And we had evidence that that was the same revolver that the defendant claimed was his in that April 14th car stop. So we believe that the nature of the weapon used in this case can be used to infer premeditation. The second factor is a lack of provocation, and the evidence showed that the group of men, the football players, were all outside talking about what they were going to do the next day. They were actually getting ready to leave the party when this white Chevy Cruze pulled up to them, and someone in the Cruze asked if they had any weed. The group responded no. Someone else asked their names, and the group either said nothing or don't worry about all that. And then the Chevy Cruze drove away, but then stopped, and then the shooting began. And our position is not telling a car full of strangers your names after they ask you for some weed and then ask you your names is not provocation at 1 o'clock in the morning, is not provocation to be shot with 3 guns 18 or 19 times. So we believe lack of provocation in this case can also be used to infer premeditation. And the third factor that the state put forward is the defendant's conduct before and after the killing. After the football players told the men in the car that not to worry about their names, the car began driving away, and it did drive away and then stopped moments later. And then the shooting began. We also have evidence from one witness who said that he actually saw people outside of the car shooting into the crowd. So the fact that the car initially drove away and then stopped in order to shoot the group of football players 18 times and then fled the scene following the shooting, we believe infers premeditation. There's also a jail phone call that the state presented where the defendant was talking to his brother about the gun and the search of the house. And they were discussing, hey, did they find your thing? They didn't find my thing. And he said something defective. No, they're not going to find it. It's not there. So we believe that phone call also talks about him not having the gun any longer that was used in the shooting and can infer premeditation. So we believe that the totality of the evidence in this case, viewed in the light most favorable to the state, does establish premeditation. And then for the aggravated robberies, I think this court's hit on the issues that essentially is the state's argument. We would argue that Clark, the passenger in the carjacking incident, did have possession or control of the vehicle enough to have the sufficient evidence of person or presence in the aggravated robbery statute. I don't know that I don't believe there's a case that says that dealing with the carjacking issue, but I think based on our this court's case law about what presence means, we can argue, and there was sufficient evidence that the car was taken from his presence. They returned to the house. I'll just go over the facts quickly. He returned to the house and they were surrounded by the defendant on one side, I think, and maybe 2 other men on the other side. So they come quickly out to surround the car. One said, "Where's the money at?" The defendant, or one of them, was at least armed with a revolver and told the driver to get out of the car. Clark was forced out of the car, but knocked over one of the men and rushed inside. So, but for them coming out and saying, "Where's the money at?" coming to them armed with guns, he would not have gotten out of the car to go inside to get his gun, is what he said. So we would argue that this evidence was sufficient to show that the car was so within Clark's control that he would have retained possession of it, if not being overcome by the threat of bodily harm or force. And then to the Central Park robberies, I think this court has already gone through the evidence that we have. I think you finished the part of the quote that I might have had in my brief talking about Ms. Cool not having anything taken from her, but the testimony that the state cited for those aggravated robberies as to Hodge and Farafontoff were, as far as I knew, Hodge got his pockets ran, so did Farafontoff. And then another witness saw the defendant and men demanding money from others and picking pockets on other people to see what they had. So we would argue that this evidence establishes that those 2, Hodge and Farafontoff, had property taken from their person.
If there's, I was gonna say, if there's no testimony that from that witness that Cool's the only one that they didn't get nothing out of, if that isn't testimony in the record, I don't see how it just got their pockets run, how that proves that there was a theft of, or a taking.
And yeah, in response to that case that said that that was just going through their pockets, I guess the state would say it's a reasonable inference to say he got his pockets ran would to be removing items from the pockets. And I guess that's my best argument as to, we would still say that's sufficient and got his pockets ran. I think there's a reasonable inference that they can say they took things from the pockets. And if there's no other questions, I guess I'll just submit.
Well, I'll turn to the prosecutorial error portion. Can a prosecutor really say that premeditation can happen in 1 second? Is that a correct statement of the law?
I don't think our case law says. I think there have been cases from this court that say you can't, the prosecutor cannot say that it can be formed in half a second or a second. I think Kettler, I can't remember.
Not say that.
Right. I think this court has said that that's a misstatement of law to say that it can happen in a half a second or a
And is
second.
that what the prosecutor said here?
Did.
So you concede error on?
We did.
On at least that one.
We did.
Okay.
Mm-hmm.
That's what I wanted to clear.
Yeah. Don't like to do it, but we did here. But he also said it can happen in 5 seconds, and that's where our disagreement is. We don't believe that he said, and I could get to it in context. After he's talking about the instruction on premeditation. And that's all it takes to form premeditation if the evidence supports it. And he had just given an analogy about picking up an envelope, which we think is a proper analogy to talk about premeditation. To have thought the matter over beforehand and then acted on it, that's what premeditation is, which is the definition that the jury got. It can be a second, it could be 5 seconds, it could be 2 weeks of premeditation. The evidence has to support that the defendant thought the matter over beforehand and then acted on it, just as that instruction tells you.
Yeah, so your concession is only to the 1 second comment, but
Yes.
in context, your argument is harmless because in toto, the proper standard was articulated to the jury.
Yes. And we presume that the jury followed the instructions, they got the proper premeditation instruction and giving secondarily, as Sherman said, the substantial evidence in this case of premeditation.
Colleagues, any other questions? Thank you, Ms. Lifkin.
Thank you, Your Honor. We would just ask that the court affirm the convictions in this case.
You're reserved 3 minutes, Mr. Latta.
Thank you, Your Honor. I have 1 point to make, and then we'll see if that leads anywhere. Talking about the Fourth Amendment and possession and control, I'll point this court to your case in State v. Schuerman. I think is how you say it. I cited in my reply brief. In that case, this court held that even though there was a passenger, that they had neither a right of lawful possession or control of the vehicle, even though they were a passenger of the car. Other than that, I have nothing else to say. If this court will please reverse and remand consistent with my brief.
Any other questions?
Thank
you, Mr. Latta.
Thank you, Your Honor.
And Ms. Lifkin for your arguments this morning. This court will take this matter under advisement.